Okay. So as various people may have heard there, the meeting has started recording, so the webinar has started recording. So we're going to be uploading this to our YouTube channel as of tomorrow. It's a webinar, so everyone here is completely anonymous. None of you will be included in the recording or uploaded anywhere. We have a chat function for people to field some thoughts into. We also have a Q&A function. So if possible, if you've got any, if possible, if you've got any questions, ideally, if you can send us the Q&A function, that's sort of an easy way of getting it to us. Yeah, so any thoughts into the chat, any questions into the Q&A, and we'll have a section at the second half of this to address those. But for the time being, my name is Tilly Smith. I am Research and Engagement Manager at Generation Rent. We're joined today by one of our own, Nye Jones, who is going to be giving an overview of the Renters' Rights Bill. If you're here for a Renters' Rights Bill webinar, you are in the correct place. That is what we're about to be doing. He'll be key off with a bit of an overview of the bill and all the sort of like top things that you as renters or friends to private renters should be aware of. And we're also very graciously joined by Sally Morshead from Shelter, who is going to be giving us some really in-depth and interesting and important bits of information about the bill, with a particular emphasis on the transition period. So all you need to know about moving from our current system to the new system. Which I will be listening very carefully to myself. So I'm looking forward to that, because I could do with learning some new things about that. Yeah, so we'll got first half with Nye and Sally, and then we've got a half an hour for Q&A. So as you mentioned, please field some questions into the Q&A as and when you get them, and we'll get to answering them at the halfway point after the presentations. So we're going to kick off our session with Nye. If we're going to start sharing the screen there, please, Nye. Effortlessly done.
Got to unmute myself there. Hi, thank you, Tilly. And thanks all for coming. So yeah, my name's Nye Jones. I'm head of campaigns at Generation Rent. And as Tilly said, I'll be doing an overview of all the changes the Renters' Rights Bill will bring in once it becomes law, and a sense of the potential timeline. And Sally will obviously be going into a bit more detail of certain facets of the bill. So I think before we get into the changes of the bill, it's important to recognise that this is a landmark day for renters across the country. Generation Rent and other renting and housing organisations like Shelter have been campaigning for a lot of these changes for over a decade. And this new law is a vital step towards rebalancing the huge power imbalance between renters and landlords that I'm sure many of you on this call have experienced, and I have certainly experienced multiple times. It doesn't go as far as we would like in certain areas, particularly around the cost of renting, but it's definitely something that should be celebrated and should be seen as a really good step forward to make renting more affordable and better quality homes. So, the headline of the bill, as I'm sure most of you are aware, is we're saying goodbye to arbitrary Section 21 evictions. Sally will be going into a bit more detail about the new grounds for eviction, but the key thing is, outside of rent arrears and antisocial behaviour, landlords will only be able to evict if they want to sell, move into, or move a family member into the home. And if they evict under these grounds, they will be banned from re-letting the home for 12 months. And we've just heard that the House of Lords has voted to keep that 12 months rather than reduce it, which is great. Notice periods will also be doubled to 4 months. So if a landlord does evict through what are called the new grounds 1 and 1A, for example, if they want to sell the home, they will have to give you 4 months notice rather than 2. And they will not be able to evict under the new, what we call no fault grounds. So if they want to sell or move in, for the first 12 months of a tenancy. And this is a change that has been the Conservative first promised to end Section 21 in 2019. So this has been a long coming change, and it's really the headline of the bill. Elsewhere, the bill will end fixed term tenancies and bring in rolling tenancies for all. So all tenancies will become what we call periodic. This means it automatically renews each month. This is a really good thing for renters. It gives renters much more flexibility. So it means you can leave the property anytime with just 2 months' notice. For example, if you move into a new home that you feel that wasn't advertised correctly and is kind of worse conditions than you thought, you can give in your notice period and leave, while still having the new eviction protections around the ending of Section 21. Next, it will give renters more power to challenge rent hikes. So under the bill, landlords will only be able to raise the rent through a Section 13 notice, and they can only do this once a year and must give 2 months' notice. Now, the system through which renters can challenge rent hikes is called the first tier tribunal. I know not a lot of renters haven't heard about it, but it is a free service that allows renters to challenge rent hikes if they think they're unfair. If you challenge a rent hike through the first tier tribunal under the bill, you will no longer be required to back pay the rent. Instead, you will start paying the new tribunal awarded rent from when the tribunal issues a decision, and the landlord's proposed rent will be the maximum you can be charged. So I think my message to people is, once the bill comes in, is use the first tier tribunal, Google it. It's quite a simple process. There really isn't a downside, because even if the tribunal awards the landlord's desired rent, you will just kick that down the road and keep paying less rent in the meantime. And of course, once Section 21 goes, the threat of a retaliatory eviction will be a lot less as well. Next, and this was a key campaign win for us and other renter groups during the process of the bill through the House of Commons, is an end to paying months of upfront rent. So we worked to amend the bill so that rent in advance will be capped at 1 month. A landlord cannot ask you to pay more than 1 month's rent in advance. Obviously, we've all seen kind of stories around renters paying 6 months, a year in advance. In some cases, this will no longer be happening. And the bill will also bring an end to bidding wars. So it will be illegal for a landlord or agent to accept offers above the advertised rent. So this, I've waited in line for half an hour to view a property before, only to be told as soon as I walk in that someone's bid £300 more than the asking price. This won't happen anymore. The advertised rent is the absolute maximum that it will be rented by. Next, the bill will look to improve the quality of homes. So it will apply the decent homes to, these are two standards that currently apply to the social housing sector, and they'll bring them into the private renters sector. And that's the decent home standard, which sets the minimum standards homes must meet, and Awab's law, which is named in memory of the tragic death of Awab Ishak from severe damp and mold. And this will set strict timescales that landlords have to meet in order to respond to issues raised by renters. These are both really welcome, because we know that over 1/5 of private rented homes are currently classed as non-decent, compared to just 1 in 10 social homes, for example, and renters wait often more than 40 days for a landlord to act on issues. At the moment, we are pushing the government to be a bit more ambitious with its timeline of bringing these new standards in. And we're going to keep working to do that, because homes need to be improved, basically. And next, the bill will bring in a new ombudsman and private landlord database. So there'll be a new private rented sector ombudsman, which will provide a free, impartial, and binding way to resolve disputes without the courts. This should be a good vehicle for renters to kind of resolve disputes with their landlords and rather stay in their homes. There will also be a new online landlord database, which will give renters more information about their home and who they are renting from. At the moment, we're working with the government and civil servants to define what will actually be categorized on that database, but we're pushing for the database to contain as much information for tenants as possible so tenants can make really good informed decisions about where they live and who they're renting off. Next, the bill will give you more powers to reclaim your rent. And this is through expanding the scope of what we call rent repayment orders. So a rent repayment order requires repayment of rent by a landlord or letting agent who has committed a specific renting offence against the tenant. Now, often at the moment, most rent repayment orders are related to landlord not having a particular license, for example, around not having a license for housing of multiple occupancy, or if it's renting in a selective licensing zone. But the bill will add 6 new offences which tenant can claim rent repayments back for. And so I've picked out some of the 3 key which I think will be used most. Provision of false information on the new database. So if a landlord is putting false information on the new private rented database, that can be a grounds for a rent repayment order. Misuse of eviction grounds, so illegal evictions, and reletting a property when they've been banned from doing so. So, for example, this could be during the no relet period. So say you were evicted once the bill is implemented, and your landlord said it was because they want to sell the home, and then you're on Rightmove looking for a new home and you see that same home listed, you could claim a rent repayment order for that, for example. And we'll be updating our Know Your Rights web pages with all the details on the new offences around these. And finally, last but not least, tenants will have the right to request a pet. I've tried to rent with a dog before and it was an absolute nightmare. So this is welcome. So landlords will no longer be able to unreasonably refuse a pet in your privately rented home. So that means no more no pets, blanket no pets kind of decisions on advertisements for homes. If you want a pet, you must ask in writing, and as I say, landlords will no longer be able to unreasonably refuse. And so yeah, that is a whistle-stop tour of the key changes coming in within the new law. As I said, Sally will be going into a bit more detail on some of those. In terms of what's next, in terms of our work and the bill, we are pushing the government to implement the bill as soon as possible. So we're hoping it is passed into law in the next couple of weeks, and then there'll be an implementation period, which has yet to be defined, but we're pushing for it to be as soon as possible, although likelihood is probably spring next year. We are pushing for government to properly fund councils to enforce it and make sure landlords are abiding by the new law. And we are working to take action to bring down the soaring cost of renting, which, as I said, is the kind of major area which the bill doesn't really address and is a huge issue facing renters right now, with huge amounts of our income swallowed up by rent. And I should add, our campaigning is kind of as good as the stories and the understanding of the sector we have. So if you are ever interested in kind of sharing your story, you can either with politicians or with journalists, for example, or just providing some insight, you can get in touch, and I'll put my email there. And that's all from me.
Brilliant, thank you, Nye. I've noticed people have already started feeling some rather excellent questions into the Q&A section, so please do keep that up, folks, and we'll get them to do them at the end of Sally's slideshow in a second. Speaking of, that's a rather brilliant segue into Sally's slideshow. I can still see Nye's thing on my screen. I don't know if that's because my screen is freaked out or if it's... Oh, it's gone. There we go. So yeah, we're joined by Sally Morshead, who's going to be giving us some more details on the bill, particularly on transition from the old system to the new. So take it away, Sally.
Hello, everyone. I think quite fortunately, my talk won't overlap too much with Nye's, although there are some bits obviously we both covered. I won't go into this timetable in any great detail, but it just shows how the bill has progressed since September 2024 till now. We are certainly spring 2025, I hope, will be the latest it comes in. It may even be a little bit before that, but that's probably being a bit too hopeful. Assured tenancies. So obviously assured short-haul tenancies are going entirely, which means that any existing assured short-hauls automatically become fully assured, which is a good thing. And another thing that's happening is that fixed-term tenancies can't be created anymore. So at the moment, you can create a fixed term of any length. You won't be able to do that if you try and create a fixed-term tenancy of 21 years or less. It'll automatically be a periodic tenancy. So the only way you can create a fixed-term tenancy after the bill comes in will be if it's more than 21 years or more than 7 years, but that has to be within 2 months of royal assent. And the effect of that is that all existing assured tenancies of 7 years or less will automatically become periodic when the bill comes into force. So there are obviously lots of new grounds for possession, and a great chunk of my talk is about that. There is a price to be paid for abolishing short-hauls. The government had to give the landlords something, and the result was that there are more mandatory grounds, more no-fault grounds, and something which they don't seem to have been terribly aware of, but all the new grounds, which are easier for landlords to get possession with, will apply to anybody who's at the moment a fully assured tenant, as well as to most people who are assured short-hauls. Now, there are relatively few private sector tenants that'll affect, but obviously if you've got a tenancy with a private landlord that started before the 28th of February 1997, which is, I know, a long time ago, you may well have a fully assured tenancy, because at that point they were default tenancies, whereas after that date, the default tenancy was the assured short-haul. So the people who lose out are the people who are currently fully assured tenants. But we're hoping, it seems the government are now suddenly thinking about this for the first time, although that seems very strange. I don't know. We hope the effect on private tenants won't be too great. So there are also improvements in the grounds, the main one being changes to ground 8. The rent arrears thresholds are going up, and I'll come onto that in a little bit. And that you can disregard unpaid housing benefit and universal credit housing costs in working out what the rent arrears are. 2 more minor ones: family members who inherit a tenancy under a will or an intestacy will become assured tenants, or at least they'll become assured tenants without being subject to a ground for possession, whereas at the moment the landlord can get possession. And landlords will no longer be able to repossess just because they want to turn the property into a holiday let. So ground 8 is changing. So this is actually, as I'm sure some of you will know, putting us back to the situation we were in 1996. So to satisfy the mandatory ground, the landlord will have to show that there's 3 months rent arrears if you pay monthly as opposed to 2 at the moment, or 13 weeks if you pay weekly as opposed to 8 at the moment. And another really good thing is that any arrears resulting from unpaid universal credit or housing benefit, which the tenant has not yet received, are disregarded in calculating how much the arrears are. Now, unfortunately, this only covers benefit which the tenant has actually been assessed as entitled to, not where the tenant has a good claim to be entitled to it or where they're appealing a decision, but only where it's actually been decided that that's what they're entitled to. But it's still very helpful, I think. And then now I mentioned the new ground 1A. This is where the landlord wants to sell the property, but they can't do it for a year after the tenancy starts, and they can't relet for a year after that. And if they do breach the no relet rule, they commit an offence, and you, the tenant, can apply for a rent repayment order. Ground 1, which we have at the moment, but it only applies where the landlord or the landlord's spouse or civil partner wants to move in, is being extended. So the landlord can use it if a close relative wants to move in, not just him or her or their spouse or civil partner. Again, as with ground 1A, it can only be used where a year has elapsed since the start of the tenancy, and the landlord mustn't relet for 12 months. Now, I really won't go into this in any great detail, but there are 4 very complicated grounds about where there's a superior lease. So some tenants, their landlord themselves will have a lease, and sometimes that landlord's lease comes to an end. And what happens to the tenant in that situation? At the moment, if it's a lawful subtenancy under Section 18 of the Housing Act 1988, that will automatically just become a tenancy of the head landlord. These new grounds are there to make it easier for landlords to take possession where that happens. They mainly benefit social landlords, but private landlords, it will only really take effect if the intermediate landlord has a lease of 21 years, which is coming to an end. So shorter leases won't be covered by these new grounds. And I think this is quite important, and nobody seems to be talking about it, but at the moment, if your tenancy predates a mortgage, then your tenancy is binding on the lender. But they're changing that. So any tenancy, any mortgage, whenever granted, takes precedence over the tenancy. So as soon as the landlord falls into mortgage arrears, they basically have a ground for possession. And they don't need to give notice of intention to use this ground. So you could have a tenancy that started 10 years ago, a mortgage that started 2 years ago. The landlord falls into arrears with the mortgage. The landlord is then able to take possession using this ground, which does seem to me really unfair. But grounds connected with employment. So in a situation where your employer lets you a property, there is at the moment a discretionary ground, but that's being replaced by a mandatory ground, and it's being extended so it can be used where it wasn't intended that the tenancy would last for the whole duration of the employment. And it's also being made available to landlords who are not the employer, who let the property pursuant to an agreement with the employer. So again, just making it easier for the landlord stroke employer to get possession. Again, there's a new ground, which I should have said, it only applies to HMOs, but there's a new mandatory ground 4A, which allows a property to let to full-time students if a property let to full-time students to get possession so they can let to other full-time students. So the idea is, I suppose, that if somebody's a full-time student, they may not always be a full-time student. And if the landlord wants to keep letting to students, this allows them to do that. They have to give notice to the students they may use that ground when they move in order to use it. But that's completely new. Ground 4 we've always had, and it's where an educational institution lets the property. That's just being made easier for the educational institution. They no longer need to serve notice before the start of the tenancy. Right. Ground 5G is a new ground where it's homelessness accommodation. So that's completely new, and will mean that private landlords can get possession of property let pursuant to the main homelessness duty, where at the moment, well, at the moment they'd be assured shortholds, but as that doesn't give any real security, I suppose it's not a huge loss to have this ground. And ground 6B is where the landlord needs possession to comply with local authority enforcement action due to prohibition orders and things like that, where the property is in a terrible state, or even where it's overcrowded. So this is what I was talking about earlier. Ground 7, it no longer applies where the tenancy passes under the will or intestacy if the occupier is living with the tenant at the date of death. So this helps children, basically, because with assured tenancies, if you have a spouse or civil partner or long-term cohabitee, that tenancy that assured or assured short-hold tenancy will pass under the statute on the death, but it doesn't pass to children. So here, because they've changed ground 7, that means that if a child's occupying the property, the landlord no longer has a ground for possession against them. And ground 3, which was always a bit of a strange one, is just going, which is a good thing. So that's it. I've rattled through the main changes, not all the changes to the grounds for possession, but I think the main ones that affect most private sector tenants. Again, I talked about rent increases, so this is broadly just repeating that. It's important to note that landlords can no longer contract out of the statutory rent increase procedure. So at the moment, if there's a term in the tenancy saying, you know, the rent will go up by, you know, £200 a month every year, then that means that sections 13 and 14 of the Housing Act 1988 don't apply at all, and there's nothing the tenant can do about it. But that's changing, so that's a really good thing. The notice of increase is now a minimum of 2 months. It was 1 month, so again, that's a really good thing for tenants. And perhaps most importantly, as I mentioned, the tribunal can't set a rent higher than the rent proposed by the landlord. So at the moment, there is that theoretical risk that if you go to the tribunal and the tribunal decides that the market rent is higher than what the landlord's asking for, you can actually end up worse off, but that's changing. So it's a really good thing. This is, again, I suppose, the fact that every private sector tenancy is now going to be periodic. Because of that, I suppose they've changed that to make the notice to quit served by the tenant 2 months. Whereas before it was 4 weeks or a period of the tenancy if that was longer. So at the moment it's either going to be a month or 4 weeks, but it's going up to 2 months. Discrimination is really quite complicated, but just to say that there are new rules saying landlords mustn't discriminate against prospective tenants with children or prospective tenants on the basis that they claim benefits, and terms in tenancies are of no effect if they prohibit or restrict children or benefits claims. And breaches of these rules must be enforced by local authorities. It is going to be quite difficult for local authorities to enforce them, partly because they have to show an intent on the part of the landlord to discriminate, which is not generally true in discrimination law, but it is true here. But we're still hopeful that it will cause a bit of a culture change. You know, it's obviously really important that that's in there. And then moving on to the transitional provisions. So if a section 21 or section 20 or section 8 notice is served before commencement of the Act, it remains valid until the end of the possession proceedings. And similarly, if section 21 or section 8 notice is served before the commencement, it can be relied on for a maximum of 3 months after commencement, even where the claim hasn't yet been issued by the court. So you can still issue, the landlord can still issue their claim within that 3 months. And whilst those notices are valid, the changes brought in by the Act to assured tenancies don't apply. So it's basically, you're still as if the Act never came in. And that's it.
Excellent, thank you, Sally. Brilliant. Well, we've got not only 2 fabulous speakers, but 2 very timely speakers, because we're now at almost exactly the halfway mark, which is also where we're going to be starting the Q&A section, which is always my favourite part of these things. I'm just going to, I'll just stop sharing this. So everyone knows it is a Q&A section. Right then. So, has that disappeared now? No, is it still there? The screen?
Still there, still there.
Still there, good, excellent. That means I can field questions to you and also hold on the screen. So we'll start off with earliest questions and work our way through. We've got one here. How will the rolling tenancies be introduced for current short hold tenancies?
shall I answer that?
Go for it.
They will just become periodic, and they will. Sorry, what? Sorry, say, was it how will rolling
How
tenancies
will rolling tenancies be introduced for current short-hold tenancies?
Well, a lot of short-hold tenancies at the moment obviously are already periodic, so they won't change, other than they won't be short-holds anymore, and there won't be Section 21. They'll just be Section 8 notices and the new grants for possession. The short-hold tenancies that are fixed term will become periodic at the date of commencement, and the period will be the periods at which the rent is paid. Does that answer it?
I believe so. Second question. So for a joint tenancy, if one tenant gives 2 months notice, that this will bring, if one tenant gives 2 months notice, this will bring the whole tenancy to an end. What happens to other joint tenants? What if what if landlord refuses to let the others resign a new tenancy?
Oh, I bet that's probably one for me as well. Yes, that the rule with notices to quit, either served by a landlord or a tenant, although obviously landlords can't usually serve notice to quit because of the statutory rules, but tenants have always been able to end their tenancies by notice to quit. And there's a common law rule that notice to quit by one joint tenant is effective to end the tenancy. That's not changing. So it's just the notice to quit is a bit longer than it would previously have been. So that does mean that if one joint tenant serves notice to quit, even if the other joint tenant or tenants are unhappy about it, the tenancy will still end, and you won't be able to insist on the landlord granting a new tenancy. I mean, in some ways it's a protection for tenants if they do need to get out of the tenancy. But equally, if you're a joint tenant who's not happy about it, it's not great. But yeah, that's true now, and that's not changing under the Act. The only thing that is changing is the length of the notice.
I would just add that landlords consistently say they kind of really don't want voids and want to keep tenants where they can. So I would hope that they would be, if you could tell the landlord early and either, find someone to replace the tenant and start a new tenancy, or find a way to keep the home, that should be the first option.
Brilliant, thank you. Another question here. I've received a Section 13 notice, so that's a notice to increase the rent, and I worry if the rent is hiked, in brackets, landlord wants £700 more, I presume that means a month more. I'm worried I can't afford this. I will apply for a first tier tribunal, but don't know what to do if I don't win the appeal.
I mean, I can jump in on that one initially.
Go
Firstly, yeah, kind of really sorry you're going through that. Sounds like a huge rent hike. I would say that at the current time, applying to the tribunal, although it's free, is the risk of a landlord kind of issuing a Section 21. So you do have to consider that if you apply to the tribunal at the moment. I can't imagine that the tribunal will award even more than a £700 rent increase, to be honest. So I imagine, without knowing the situation, it would be worth challenging to potentially bring a lower rent increase. And there's really good advice, for example, on Shelter's pages about how to do that. And the tribunal, what it will do, it will decide on what it deems a fair market rent is for the property, and that will be new rent, basically.
Brilliant, thank you, Nye. Got another question here. So landlords cannot ask for rent in advance, but will renters be allowed to offer more in advance? I'm still very concerned about the guarantor situation and whether I will be able to rent again.
I don't think they will. I'm not 100% sure of that, but I don't think. Nye, do you know the answer?
I'm I'd say 99% sure that landlords cannot accept more than 1 month's rent. Can't ask for it and they can't accept it. So 1 month will be the maximum.
I mean, I think that's designed as a protection for tenants so that
Yep.
landlords don't try and dress up the pressure that they're putting tenants under to pay more in advance as an offer.
And we found that paying large amounts of rents in advance tends to help people from more affluent backgrounds or or higher wages, but obviously because they can either draw on familial money or their own savings to do so. So it's quite hard and fast, that rule.
Thank you. I'm not sure what they I mentioned with the guarantor system, but people will still be able to have guarantors as well, is my understanding of the new system.
Yeah, we've been lobbying really hard for them to place restriction on guarantors because it's really unfair and cuts many people out of renting who don't have wealthy parents who could guarantee things. But yeah, it's fallen on rather deaf ears.
Thank you. Another question here. May I ask what the other grounds are for rent repayment orders? So I think you mentioned licensing in the context of this question, and there were other grounds.
So I mean, I've got them on my screen. So the bill, there's currently 7 offences that rent repayment orders apply to. As I said, these tend to be around licensing or failure to comply with like an improvement notice, for example, as well as unlawful evictions or harassment. The bill will bring in 6 new offences. I can read them all out. So continuing or repeat breaches of the landlord redress schemes, so schemes to kind of hold landlords to account. Provision of false or misleading information on the private rented sector database, continuing or repeat breaches of the private rented sector database. So, for example, not uploading information on the database, knowingly or recklessly misusing a possession ground, so an illegal eviction, breach of restriction on letting or marketing a dwelling or house. So the example I gave was breaching the no relet period, and tenancy reform, continuing breaches, which, to be completely honest, I'm not 100% sure what that applies to. I don't know if Sally knows on that one.
Sorry, say again.
Tenancy reform, continuing breaches.
Tenancy reform, yes. Where is that? If I knew which clause in the bill that was, I think I'll have to do some thinking about that.
But yeah, in the main, it's around the database, illegal evictions, and breaching restrictions on letting a property.
It is always worth saying that licensing grounds are pretty much the best way of getting landlords on rent repayment orders. So we have a dedicated session to that on Friday, if anyone's interested in finding out how to get some of your rent back. And as someone who's personally going through that system, and will hopefully be getting about 6 months of rent back at some point, I can only strongly advise you learn more about it. So there we go. Friday has been pushed. So the question here, do you have any concern as landlords are leaving due to tax and regulation? I'm sure both of you can answer that, but Nai, I suspect you have a...
Yeah, I mean, it's not the first time I've answered the question, so I can start. I mean, I think the first thing I would say is that our homes are the foundations of our lives. And these new regulations aren't that taxing, providing a decent quality home at a fair price and not being able to evict tenants on a whim isn't too arduous. And any landlord that does look at these new regulations and thinks, I don't have the capacity or the time or the wherewithal to abide by those, I'm going to sell up, is not necessarily a bad thing. Firstly, I would say that if a landlord sells a home, the home doesn't get demolished. It could be bought by a renter looking to buy or someone looking to move home and actually live in it, or it could be bought by maybe a more professional landlord who is more able to abide by the new regulations. And I think overall, the private rented sector is far bigger than we ever imagined. And this combined with kind of creating a lot more social housing should level things out. So no, is the short answer to that.
Brilliant, thank you. I'm not sure if either will have an answer to this, but I'll ask it as someone has posted it to the thing. In our area, I've heard of students who think they are secured. They have secured the property they have been renting to stay in for the following academic year, only to find during the summer vacation that landlord has relet the property over their head at a higher rent to someone else. Is this legal?
No, it's not legal. If they still have a tenancy, which it sounds like they do, then that's an illegal eviction. So it obviously depends on the facts, but I imagine the students have all their belongings there and they've got the keys and they're paying the rent. So if that's the case, the landlord, yeah, I'm slightly surprised that the landlord can, practically speaking, do that without reaching an agreement with the previous tenant students. But yes, it's, you know, if you've got a tenancy, I mean, you've either got a periodic tenancy which can only be ended by Section 21 and taking possession proceedings, or you've got a fixed term tenancy which will also either will come to an end automatically, but if you don't move out, then the landlord would have to take possession proceedings. So it's very fact sensitive, but it's definitely not okay for a landlord to do that.
It sounds like a very interesting case. If you've got any other details you want to send to us, the best do come on to that, then we'll be happy to hear them, I'm sure. Yeah, they know the best reputation student landlords. Some may argue there's a reason for that. Another person said, "What happens if I have a more favourable rent increase clause in my contract than the principles applied by the first tier tribunal?" That's a quite interesting question.
Good question.
Just looking at the changes to how it's drafted. Bear with me. Yeah, so
I can answer the next one if that helps.
Sure. Should we go? We'll come back to that one and then we'll quickly. Yeah, next one is, how would anyone know if a landlord is being discriminative, though?
Yeah, it is. I mean, it is difficult to prove and often relies on tenant testimony, and kind of records of conversations and things. We did manage to resist. The Lords wanted to amend the bill to increase the kind of threshold of evidence around these things, and we managed to resist that. And often it will be councils who make a decision on this. So I would say if you think a landlord is being discriminatory, kind of keep a paper trail and get in touch with your council to flag the issue.
Yeah, it is a shame because, as Sally mentioned, you have to prove intent. So you have to prove in these cases that the landlord has meant to discriminate against certain groups, which is obviously harder than.
I mean, I think there's going to be an issue with obviously with local authorities having the resources to enforce all these provisions, but I think everybody needs to be really providing them. They're not going to know unless tenants provide them with this information, and you would hope that the best authorities would at least try to do something, or at the very least collate the information, and you know, that could be used in some future campaign to make the legislation easier to use. So yeah, it's definitely worth doing. Yeah, so going back to the question about Section 13. So the current Section 13 says that it applies to any assured tenancy, except for those where there's a provision in the tenancy where the rent for a particular period of tenancy will or may be greater than the rent for an earlier period. So they've taken that bit out. So now Section 13 is going to apply just to any assured tenancy. And the only way that the landlord can increase the rent is by, I'm trying to think of a situation where that would not favour the tenant. The only way the landlord can increase the rent is by serving the notice, and then the tenant can go to the tribunal. I mean, I suppose if you've got you're not going to have a term in the tenancy saying the rent's going to go down, are you? So it's hard to imagine a situation where tenant will really lose out from this, because any rent review clause is going to make the rent go up, you'd have thought. And at least this ensures there's some check on that. But yes, I mean, yeah. So basically that is the only way that the landlord will be able to increase the rent, is by serving this section 13 notice.
The only case I can think of is if your rent is so low compared to market rents that even with rent increase clauses,
yeah, that's true,
it's lower than the tribunal, but that would be unusual, I suppose.
But it would be very unusual to have that built into the tenancy. I mean, yeah. the landlord can still serve a section 13 notice proposing any rent, and the rent proposed could still be very low and far less than market rents in the area. It would be nice if they did that. So it shouldn't adversely affect tenants, I hope. It's done in this way to stop landlords building into the tenancy itself these really punitive mechanisms for increasing the rent.
I've got a question here on more sort of practical things. So is there a live update for the bill progress from the Parliament website, like from Parliament, like a website to check the date it will be implemented?
So I can jump in on that. So I've just seen that basically the Lords have voted to pass the bill, so they haven't either failed or haven't pushed any of their amendments, which is great news. So that means the bill will not be going back to the House of Commons again. It will be passed. We expect what needs to happen now is for royal assent to be given, which is an old tradition where basically the king approves it. And then once royal assent is given, we expect the government to announce an implementation date. So a date that the vast amount of these reforms will come in on.
Brilliant. I've got a question here. So with the rent advance payable for 1 month only, when this is brought in, does it mean that 6 or 12-month payments upfront will be abolished completely? Since this facility was helpful for self-employed people at times.
Yes, I think it will be impossible.
Yes.
I think it is worth mentioning on the kind of like thing, because I know people's anxieties around like removing or banning things or restricting things that sound like they've sort of been helpful. But we are hopeful that if landlords can't do this, then they can't do it for everyone. So they'll stop kind of, sort of like no one will have to pay these sorts of rent up front, so they'll have to start like treating everyone properly and equally. That's what the sort of idea is and the sort of plan, because obviously some self-employed people might be able to have 6 to 12 months of rent up front, whilst others won't. Some people on benefits may have 6 to 12 months of rent up front, whilst others won't. Whilst this system is, we hope, will be a fairer one with everyone kind of on an equal playing field. But yeah, we will obviously see the information of the bill and how well it goes. Well, the question is, in case of a tenant landlord that is then a case of a tenant landlord, I'm not sure what that means. I'll read the question first, so we'll try and work out what it means. In the case of a tenant landlord that is then privately renting to a tenant, I think they mean in the case of a landlord that is then privately renting to a tenant, if the tenant landlord dies, how will that affect the private tenant? Don't know if we can decode that.
Does this might mean a living landlord, so a lodger?
It might mean a living landlord.
That's not changing. I mean, there's a period within which the estate can get possession, because the residential landlord status basically continues for a period after the death, if it is a residential landlord, and because it won't be an assured or an assured short hold tenancy because of the residential landlord. So that may be, but that, I say, that's not changing because of this bill. That it's staying the same.
Question here. Can you elaborate on how the landlord database will be useful to renters or prospective renters? Will this be something that will be we will be able to access, or is it only local councils?
yes, tenants will be able to access it. There's a question, it's likely that tenants might be able to access less information than councils, for example, but tenants will be able to access it. I would add that it's not written into the legislation what the database will record, and so government is working on deciding that at the moment. But obviously, the more we are very much pushing for as much information as possible, so it's as useful to tenants as possible. So it could hypothetically record things like accessibility issues. So if you were living with a disability, you could look on the database and see whether a home might fit your needs before having to go and view it, for example. It could potentially record similar rents in the area, and you can understand what might be the kind of the right market rent for a home in the area. And potentially it could record like any action taken against the landlord in the past, so you have a better understanding of who you are renting from. But as I say, all of that is yet to be confirmed. But yes, hopefully it will be a useful resource for tenants.
Yeah, we're Generation and Shelter are both campaigning as hard as possible to get as much on the databases as possible. So when it's asked, will annual rent reviews be compulsory? So I think that might be the wrong end of the stick slide, which is that's my mind is no, they'll be illegal, right, Sally?
No, quite the opposite. So the rent won't, nothing will happen to the rent unless the landlord serves Section 13 notice. They're definitely, I mean, the most they can do it is once a year, but they certainly don't have to. And if they want to leave you on the same rent for longer than a year, that's great. Yes, there's no sense of it being compulsory that it should go up every year.
A lot of questions about renting. Rent things. I'll try, and I'm aware we're running out low on time, and there are quite a lot of questions. So I'll try and get to as many as possible. Someone said, what about rent increases? When the landlord increases the rent, as usually in 12 months, short-held assured tenancies, the landlord cannot increase the rent for 12 months, question mark. So I think it's how often they can increase the rent once every 12 months. I think that's basically what
I mean, that's not changing. I mean, the mechanics of it's changing slightly because obviously fixed term tenancies are becoming periodic, but yeah, they won't be able to do it more than once every 12 months.
Someone said, when do you expect the bill will become law, which is harder to answer than you might think it is. Nine?
I mean, I can give my best guess, which would be sometime early 2026, likely March, April 2026, but we don't know until the government says.
It is worth mentioning there'll be like a small gap in between when the sort of bill becomes an act and gets rules and when it actually becomes enforceable by law. Yeah.
It's important to know that the bill becoming an act through royal assent does not mean Section 21 is you can't be evicted with Section 21. That will happen on the implementation date and not the bill becoming an act.
But yeah, we'll make sure to make it very clear as possible when that happens, when we get that information. Someone said, are new tenancies now known as indefinite tenancies? So that's a bit of language clear up, I think, there.
I don't think so. I mean, that may be what people call them, but in law, they're really periodic tenancies because that's what they are. They have a period and they just carry on indefinitely until they're ended by notice to quit by the tenant or a court order if it's the landlord. But yeah, I mean, people call them indefinite, but yeah, it's a perfectly decent term to use. But it's not a legal term. Periodic in law, the distinction is between periodic and fixed term are just going. So everything's going to be periodic.
Yeah, I think sort of companions, including ourselves, tend to use the terms indefinite and rolling into.
I mean, they're fine. There's nothing wrong with using those terms at all.
But just to clarify, when we say indefinite tenancies, we do mean rolling tenancies. This person said, it's a question that I haven't thought of, so it'd be interesting to hear. Will tenants be able to negotiate 1 month's notice to leave the property, as asking a new landlord to hold the property for 2 months can be quite tricky? Or will this change the landscape so much that it will be expected? There's a second question, but I'll leave it up to you for now.
They can agree a shorter period with the landlord, but whether landlords will want to, I don't know.
And the second question is, will the landlord database say if a landlord is waiting the 12 months to be able to relet, the tenants can check?
We don't know. It's a short answer. It may give that information to councils and not tenants. We don't know yet. As Tilly said, we're pushing for as much information as possible.
Okay, we've got 5 minutes left, and there's quite a quantity of ones to go through. I might sort of start going through and picking up ones that haven't really been addressed. Someone says, how can we check market price? So this will be about rent increases.
Yeah, I think that's quite difficult. When I've historically been advising tenants about whether they should go to a tribunal or not. It's actually really difficult. I suppose I just contacted local estate agents and see what they were letting agents letting properties for, and try and work out if they're equivalent to your property, but it's not easy.
Someone said, will the right to request a pet apply to existing tenancies? My understanding is yes, it will. So that's a quick yes, that'll just change.
There's a question on, will there be a set maximum percentage that landlords can increase the rent by in line with inflation? No. We did push hard for that to come in, and that was rejected. So landlords can increase the rent by what they please, but then you can take it to the tribunal, and the tribunal will decide on what they think a fair rent increase is.
Brilliant. Sorry, my mouse is doing a weird flicky thing with the Q&A. I don't know, because we've had one more substantial word. Someone says, will tenants need to sign new agreements once this comes in?
No, they won't. The tenancies that they have will automatically be converted. There's no, and will continue. And there's a specific provision in the bill saying it's not like a new tenancy that starts from the date or the bill is implemented. It's just the tenancy you have carries on and changes.
The question's asking, what happens if I have a joint tenancy and my ex-partner decides to finish the tenancy before 2 months of ending the contract? What are my rights?
Before 2 months of ending the contract? Sorry,
before 2 months. Sorry, before 2 months of ending the contract.
What does that mean? Sorry. So the joint tenant can end the tenancy by serving notice to quit of 2 months, but
I don't know if that means if they stop paying the rent before 2 months, they just sort of...
That wouldn't end the tenancy, obviously, stop paying the rent, but it would cause rent arrears.
Yeah, I suppose in that case, if it is a joint tenancy, you'd be liable.
Yes.
Both of you are equally liable to pay those rent arrears. But yeah, if it's a joint tenancy, it ends with the 2 of you, or it doesn't. It's not like one person can just leave it. Someone asked, this might be our second to last question. I have a disrepairs claimant. I have a disrepairs claim. Oh goodness. I have a disrepairs claim and have also received a Section 13 notice. Does that make a difference? I think it's all the questions.
I mean, the tribunal will take into account the quality of the home alongside the kind of local market rent. So yes, it could help your case that the rent increase is not fair.
Yeah, just put as much evidence as you can before the tribunal so they can see what state the property's in.
Brilliant, thank you. I'm having a through the questions. I think kind of everything has been asked, even if I haven't sort of got to every question. Will be, I'll stop sharing now. So I'll be showing around both these presentations as well as this recording and any other relevant URLs. I'll be showing our fact sheets and our Know Your Rights pages. So hopefully if anyone has any sort of like burning questions that they don't think were answered in those will help. We've also got some information on our website about the bill, so you can sit down and read it in your own time. We can't offer case-by-case support, unfortunately, at Generation Rent, but if you do contact us with any sort of concerns or questions, we may be able to signpost you in the right direction. So please do feel free to do that. And I'll just finish up with the what you can do next bit. So if you've enjoyed this session, so I've got to be tabs open now. So enough now, I opened the wrong. Yep. No, it's good. Right.
Going so well to this point, Toby.
Can everyone see that? 3 ways to stay involved?
No.
No. I knew it was going to go wrong at one point. Sorry, folks. There we go. Now?
Yeah.
Yes, there we go. So we've got 3 ways for people to get involved. If you've enjoyed this session and found it useful, then wonderful. If you're sort of interested by us at Generation Rent and you want to sort of work out how to get more involved with us, there are 3 ways here. I will send these around in an email tomorrow, so don't really have to sort of memorize them or write anything down, but just so you're aware. We're always collecting stories. We are really keen to use your experiences through our work to make sure that it informs everything that we do, and getting your stories to people in positions of power, media, and to politicians is sort of the best way of doing that. So if you've got any story you want to share, and you'd be interested in working with us to share those experiences, we have a very big spot on our website to do so, which is here. We are, alongside our Renters' Rights Awareness Week, hosting a prize draw, and we've got a wonderful selection of books to win. We've got Quay Joe's latest book, and so has the author, whose name has now slipped my mind, Sally Rooney. Her latest book as well is available, as well as a whole host of housing-related others. So please do take part in the prize draw if you have a couple of quid to spare. And if you're interested in pushing for a stronger renters' rights bill, we have a dedicated campaign page here. So as people mentioned, getting as much onto that all-important landlord register, and just improving the bill, really. That's how we're going to go about doing it. So there we go. We are 2 minutes over, so apologies for that, but very nearly got there in on time. Thank you so much, everyone, for joining us. As I said, we will expect an email from us tomorrow with all the relevant resources on it. But for now, I'll let everyone go, and it's goodbye from Nye and Sally.
Bye.
Bye.
And it's goodbye from me. Good night, everyone. Hope you enjoyed that, and yeah, see you later.